You're right, mate. My name is George. I'm a lawyer, educated across various jurisdictions. This is going to be my very first YouTube video. I have this dream of creating a YouTube channel on which I can share all my knowledge of EU law with everyone. As you probably know, EU law has become very important as EU law has permeated every nook and cranny of our society. Not only in the 30 plus EU, EEA and EFTA countries, but also outside the European continent. In today's video, I'd like to touch on the topic of the sources of EU law. When it comes to EU law, there are primary laws and secondary laws. The primary laws often refer to, first, the Treaty on European Union, which is often abbreviated as TEU. Secondly, the Treaty on the Functioning of the European Union, which is shortened as TFEU. You may wonder why there are two treaties. The framers of the EU laws had to create two treaties mainly because of political reasons. However, you don't need to worry about that, as Article 1.2 of the TFEU says, the TFEU and the Treaty on European Union constitutes the treaties on which the Union is founded. These two treaties have the same legal value. They shall be jointly referred to as the treaties. When we discuss about the treaties, we shouldn't overlook the protocols and annexes. There are in total 37 protocols and 2 annexes. Article 51 of TEU says that these protocols and annexes form an integral part of the treaties. Besides the treaties, the protocols and annexes, the Charter of Fundamental Rights of the European Union is another primary source of EU law. This is arranged in Article 6.1 of the TEU. Article 6.1 of the TEU says the Union recognizes the rights, freedoms, and principles set out in the Charter, which shall have the same legal value as the treaties. In addition to the Charter, the general principles of the Union's law form another source of a primary EU law. The general principles are fundamental principles of justice of the EU and its member states. A large number of the general principles are developed by the European Court of Justice in Luxembourg. They are part of the EU law with which the EU institutions and the member states need to abide by. Some examples of the general principles are, for instance, the concept of legal certainty, the principle of a sincere cooperation, the principle of a proportionality, and the principle that EU law cannot be relied on for abusive or fraudulent acts. With regard to this last example, you can have a look at the recent C14/23 Perla case, dated the 29th of July 2024. In paragraph 38, the court says that a member state must refuse to grant the benefits of the provisions of EU law where they are relied on not with a view to achieve the objectives of those provisions, but with the aim of benefiting from advantage in EU law, although the conditions for benefiting from that advantage are fulfilled only formally. The court also reiterates that the application of that principle is not subject to a requirement of a transposition. In other words, the Union law principles apply without transposition, which is very different from how a directive works, which we will discuss in a minute. Last but not least, in addition to the treaties, the protocols, the Charter, and the general principles of Union law, international agreements with the EU can be a primary source of EU law as well. For example, the Withdrawal Agreement and the EU-UK Trade and Cooperation Agreement and the association treaties with, for instance, Turkey. Now we turn to the secondary sources of EU law. I'd like to refer to Article 288 of the Treaty on the Functioning of the European Union, as this provision gives a lovely summary of the secondary EU laws. Please let me quote. To exercise the Union's competencies, the institution shall adopt regulations, directives, decisions, recommendations, and opinions. Every act of the secondary EU law must be based on a provision of primary EU law. Legal basis must be explicitly stipulated. The same provision explains what these bits and bobs are. A regulation shall have general application. It shall be binding in its entirety and directly applicable in all member states. Let me give you an example. For instance, Schengen Border Code Regulation 2016/399 is an EU regulation. For example, in Article 6 of this regulation, you can find the entry requirements that a third country national needs to meet before they can be admitted into the Schengen area. It relates to something that needs to be applied uniformly across the entire Schengen area. Thus, it needs to be arranged in a regulation rather than in a directive. A directive shall be binding as to the result to be achieved upon each member state to which it is addressed, but shall leave to the national authorities the choice of a form and methods. For example, if you want, you can take a gander at European Blue Card Directive 2021/1883. Article 5.3 of the European Blue Card Directive says that the salary threshold shall be set by the member state concerned after consulting the social partners according to national practices. It shall be at least 1.0 times, but not higher than 1.6 times. The average gross annual salary in the member state concerned. Apparently, it gives the member states the leeway to make their own choices within the bounds set by the European Union. Thus, a directive is the correct instrument for this purpose. A decision shall be binding in its entirety. A decision which specifies those to whom it is addressed shall be binding only on them. When it comes to a decision, you can think of, for example, the sanction levied by the European Union against an individual, such as a war criminal. Recommendations and opinions shall have no binding force, but they may have interpretational value for national judges on the basis of the EU principle of sincere cooperation. Now let's discuss the hierarchy among these laws. Primary EU law is above secondary EU law. In the event that the secondary EU law is contrary to a primary law, the secondary EU law can be invalid. There is a very interesting example, namely Digital Rights Ireland case of the 8th of April 2014. The court held that by adopting Directive 2006/24, the EU legislature has exceeded the limits imposed by compliance with the principle of proportionality in the light of Articles 7, 8, and 52(1) of the Charter. Directive 2006/24 is therefore invalid. Between the primary law on the one hand and the secondary law on the other hand, there is a hierarchy. However, among the regulations, directives, and decisions themselves, there is no hierarchy. Depending on the nature of the business, the EU can choose in which form it wants to legislate. Okay, this is what I want to share today. I hope you like my very first YouTube video, If so, please feel free to give this video a thumbs up and share it with your friends. Thank you for watching. Hopefully see you soon. Take care and bye bye. Cheers.